Good morning. Hearings. Financial. Let me start again. Good morning. This is the time and place for the hearing officers' hearings for June 9th, 2010. My name's Wolfgang Kraus. I'll be the hearing officer for the first case today, and Jeff Hamilton will be the hearing officer for the other cases. We've got conditional use permits and a variance. So with regard to the procedure now, if there's a variance, then that's going to be considered under the provisions of Title 30, Chapter 30.43 of the Glendale Municipal Code, which provides that a variance shall be granted if four required findings are present. And they are, number one, that the strict application of the ordinance would result in practical difficulties or unnecessary hardship inconsistent with the general purposes and intent of the ordinance. Number two, that there are exceptional circumstances or conditions applicable to the property involved or to the intended use or development of the property that do not apply generally to other property in the same zone or neighborhood. Number 3, that the granting of the variance will not be materially detrimental to the public welfare or injurious to the property or improvements in such zone or neighborhood in which the property is located. And 4, that the granting of the variance will not be contrary to the objectives of the ordinance. Now, with regard to the conditional use permit applications, those are heard under the provisions of Title 30, Chapter 30.42 of the Glendale Municipal Code, which provides that a conditional use permit can be granted if these 4 required findings are present. And they are, number 1, that the proposed use will be consistent with the elements and objectives of the general plan. 2, that the use and its associated structures and facilities will not be detrimental to the public health or safety, the general welfare, or the environment. Number 3, that the use and facilities will not adversely affect or conflict with adjacent uses or impede the normal development of surrounding property. And 4, that adequate public and private facilities, such as utilities, landscaping, parking spaces, and traffic circulation measures, are or will be provided for the proposed use. Now, we do have a conditional use permit related to the sale, serving, or consumption of alcoholic beverages. There are also 5 criteria that have to be considered in making the above findings. And they are, number 1, that the census tract with more than the recommended maximum concentration level of on-sale or off-sale uses, and as recommended by the California Department of Alcoholic Beverage Control, that such use does not or will not tend to intensify or otherwise contribute to the adverse impacts on the surrounding area caused by such overconcentration. Number 2, that crime reporting district location of the existing or proposed use with a crime rate which exceeds 20% of the city average for Part 1 crimes, as reported by the Glendale Police Department, that such use will not tend to encourage or intensify crime within the district. Number 3, that existing or proposed use does not or will not adversely impact any church, public or private school or college, daycare facility, public park, library, hospital, or residential use within the surrounding area. Number 4, that adequate parking and loading facilities are or will be provided for the existing or proposed use, or other reasonable alternatives satisfy the transportation and parking needs of the existing or proposed use. And 5, that notwithstanding consideration of the criteria in subsections 1 through 4 above, the existing or proposed use does or will serve a public necessity or public convenience purpose for the area. Okay. Now, after the hearing, the decision will be prepared in writing, be in the form of a letter sent to the applicant and to all persons who have given us information, either at this hearing or in writing, and who have left us their name and mailing address. The date of the decision is the date that's going to appear on the letter itself. Now, under the appeal provisions of Title 30, Chapter 30.62 of the Glendale Municipal Code, the decision may be appealed to the Planning Commission within 15 days of the date of the decision. Anyone wishing to appeal can get the necessary forms and information from staff located in our permit center right here on this floor. And if you haven't already done so and you want to speak, please fill out one of these speaker cards and provide it to our planning assistant, Mr. Combs. Also like to inform everyone that the official proceedings of the zoning administrator's hearings are recorded on tape as part of the public record. And obviously we're also on television. So when you speak, please give your name and mailing address. Now, the first case is actually a consideration of a revocation. So that's under the continuing jurisdiction that the city has with regard to cases that we've approved in the past. So the first case is a continued hearing, and so I'm going to open that case right now. That is case number PCUP 2007-032 at 3463 Foothill Boulevard. This was continued from the June 2nd, 2010 hearing. And the business name is Urartu Restaurant. Business operator is Sarob Sarobian, who's also the owner. And this is continued consideration of the revocation of conditional use permit PCUP 2007-032, granted on April 11th, 2008, to allow the on-site sales, service, and consumption of alcoholic beverages at a full-service restaurant. Consideration of said revocation is based on the fact that the use has been operating as a banquet hall instead of a full-service restaurant with banquet facility and expansion of the existing floor area without obtaining the required approvals, thereby violating the zoning code and conditions of approval of the conditional use permit and the zoning use certificate. Again, at 3463 Foothill Boulevard in the C3 Commercial Service Zone, Height District 1, and the rear portions in the R1 Low-Density Residential Zone, Floor Area Ratio District 2. And this is a portion of Lot 2, Block K, Crescenta Cañada Tract. All right. Again, we opened the hearing. We took some testimony last time, so let me ask Ms. Toledo to briefly introduce the case.
Thank you, Mr. Krause. Again, Milka Toledo, I'm the case planner on this case. At the last hearing, which took place a week ago today, I did summarize the staff report before you. In addition, I included the conditions of approval of the conditional use permit that are being violated, and so therefore I'm not going to go over that again.
Okay.
We did receive and heard some members of the community, and they provided their public testimony on this case. In addition, we did receive from the business owner's representative a request to continue the case for a week, and that's why we're here today, on the terms that they requested to continue the case. And in addition, since then, we've received additional correspondence or communication from the police department and neighborhood services, and that those letters or memos have been included in the case file for your review. And finally, late yesterday, we did receive a hand-delivered correspondence from a law firm requesting that this case, again, be continued for an additional 2 to 3 weeks.
Okay, thank you. I know the recent request was based on an attorney firm being hired as late as Monday afternoon, so I don't quite understand that. I don't know what happened to the other 2 attorneys that were supposedly working for the owner. So we're going to continue with this hearing. So first I'd like to ask the representatives of the city to kind of highlight things that they have already put into the record and if they have new information. So let me start with neighborhood services, and then we'll go to the police department.
Good morning, Mr. Krause. My name is Thomas Solar. I am the Neighborhood Services Inspector.
Okay.
Neighborhood Services is requesting the revocation of conditional use permit case number PCUP 2007-32 issued to the owners of Urartu Restaurant. The CUP is no longer valid based on the following facts. The current floor plan configuration has been significantly altered or modified from the approved floor plan under conditional permit PCUP 2007-032. This was evident by the following: the construction of a storage room and a bathroom at the rear of the property to include new exit doors, windows, plumbing, and electrical lightings. These alterations and modifications violate conditions number 1, 2, and 6 of PCUP 2007-032. Noise disturbances generating calls for service caused by the business documented by the Glendale Police Department. This violates conditions number 7, 14, 18 of the CUP 2007-032. They continue to provide and or allow live music and dancing without proper city approvals or permits. This also violates conditional use permit PCUP 2007-032, condition number 3. And furthermore, we are also amending our request to include to cease and desist any and all operations related to banquet halls or private parties that activities that exceed the 30% of the serving area. The following is actually just a timeline summary of our case.
Okay.
On January 10th, 2009, we had received an anonymous complaint by Neighborhood Services concerning a new addition at the rear of the building on or near the property line. The request for service was assigned a case number and scheduled for myself to inspect. On January 15th, 2009, an initial inspection was conducted by myself and found, after reviewing the plans on record, an attached addition at the rear of the property to include a new storage room and a bathroom. At the time of the inspection, it was also evident there was some accumulation of junk, trash, debris at the rear of the property, to include some discarded tires, crates, bottles, and the trash enclosure was being used to store 2 barbecue grills. On January 26, 2009, proper notification was mailed to the owner, listing the violations and remedies as follows. The construction of a storage room and a bathroom at the rear of the property without city approval or permits violates conditions numbers 1, 2, 6 of CUP 2007-032. The accumulation of junk, trash, debris at the rear of the property violates condition number 4 of CUP 2007-032. And the letter also included notification of multiple noise disturbance calls for service generated by the Glendale Police Department dating back to October 25th, 2008. This violates the conditions numbers 7, 14, and 18 of CUP 2007-032. A follow-up inspection date was scheduled for February 17th, 2009. On February 17th, 2009, an inspection was conducted, and after reviewing the city record, there was no application in process to legalize the addition at the rear. The junk, trash, and debris had been removed, and if any requests for service from the Glendale Police Department between our last inspection on January 26th to our current inspection can be best answered by proper Glendale Police staff. On March 5th, 2009, I had a conversation addressing all of the issues and remedies with the owner of the business, Mr. Sarabian. He stated that proper application was in process to legalize the addition at the rear, and we had granted a 30-day extension. On April 7th, 2009, a follow-up inspection was conducted, and the violation for the addition of the rear still remained. I contacted Mr. Gabriel Riza of Community Planning on April 10th, 2009, at which time, again, no current application existed on record to legalize the addition at the rear of the property. On May 14th, 2009, a notice of office conference was mailed to the owner listing the above-mentioned violations. And then on May 28th, 2009, the office conference notice was posted on the property, and all noted violations still remain. On June 11th, 2009, an office conference was held at Neighborhood Services Conference Room, at which time only Mr. Garo Nazarian of Domus Designs was present and or representing the property owner. A final inspection was scheduled for July 20th, 2009.
Mr. Soler, can I just stop you there?
Sure.
So that was a Neighborhood Services office conference. What was decided at that conference? What was agreed to, if anything? You remember?
I have it here.
Okay.
At the office conference decision reads as follows. It says, immediately remove, properly dispose any all trash, junk, debris at the rear of the property. Install trash bin inside the approved trash enclosure. Failure to comply with this notice will result in revocation of CUP 2007-032. Immediately comply with conditions number 7, 14, 18 of the CUP condition. Again, PCUP 2007-032. And it says within 30 days, restore the floor plan to the approved condition, use permit PUC 2007-032, or apply for a new CUP through the planning department. Failure to comply with this notice will result in may result in revocation of CUP 2007-032.
So as early as June 11th, 2009, they were told to either demolish the addition or apply for, okay.
Apply for, that's correct.
New CUP, okay. And we had advised them that we could consider revoking the existing conditional use permit at that time.
That's correct.
Okay. All right, thanks. Proceed.
All right. I'm sorry?
No, you can go ahead.
Okay.
Go ahead.
All right, so on June 20th, 2009, I had conducted an inspection on or about 7:15 p.m., at which time there was about 10 to 12 cars parked on the lot. I approached the security guards and introduced myself and the purpose of my visit. The front doors were closed but operable, with an 8x11 sign with large, bold red letters stating private party. I was approached by a Mr. Armik Shanazarian, who at the time allegedly representing the owner, Mr. Sarabian, and Mr. Shanazarian asked me if I was on the guest list, to which I had replied no. After a lengthy discussion related to the restaurant use, we agreed to set up a meeting with the owner to discuss the issue of solely operating as a banquet hall or allowing private parties to exceed the maximum serving floor area of 30%. There was no interior inspection allowed by staff, and given the facts that the private party sign was posted on the front door, and I was asked if I was on the guest list, there was probable or reasonable cause and evidence that the restaurant was not open to the public and were in preparation to conduct a banquet hall or a private party exceeding the 30% allowable serving area. An email was generated to Mr. Sam Engel, Mr. John Brunel, and Mrs. Yvette Neukin on the result of my inspection.
So they didn't let you inside?
At the time, no.
Okay, well, that's a condition violation, too.
On June 25th, 2009, proper written notification, a 72-hour letter, was mailed to the owner with the addendum violation requesting that the owner cease operations as a banquet hall and or cease from taking reservations for private parties that use more than 30% of the service floor area. On June 29th, 2009, a follow-up inspection was conducted. At the time of the inspection, the restaurant was open to the public, and there was no evidence of a banquet hall or private party activity. Mr. Saradian stated that the restaurant is always open to the public during normal business hours to include lunch and dinner. But Mr. Sarabian also stated that he has documents that reflect multiple dinner reservations as part of his normal operations. Since our notification on June 25th, 2009, it has been a challenge for us to confirm that the restaurant solely operates as a banquet hall. On July 20th, 2009, a final inspection was conducted pursuant to the decision made on the Offerance Conference of June 11th, 2009, and the violation concerning the addition of the rear property still remains. Mr. Sarabsarian stated that the proper documentation was in progress to legalize the addition at the rear. On January 4th, 2010, a monitor inspection was conducted, and prior violations, as noted, still remain. And an additional violation was noted and discussed with the owner related to parking or storing an abandoned inoperable boat on a required parking space, as evident by flat tires, and the boat was covered with a blue tarp. At this point, the case was referred to the city attorney for review. On January 6, 2010, the request for the revocation of conditional use permit, PCUP 2007-0-32, and the revocation of the zoning use certificate number 2008-0363 was submitted. On January 19, 2010, the city attorney referral notice was mailed to the owner. On January 26, 2010, a revised city attorney referral notice was mailed to the owner. And on February 25, 2010, the notice of intent to file a criminal complaint was mailed to the owner. March 22, 2010, a follow-up inspection for the city attorney was conducted, and all violations noted still remain. And on March 31, 2010, a request to amend the original revocation request dated January 6, 2010, was submitted, as evident by the operator owner continues to conduct a banquet/private parties that use more than 30% of the floor service area, as evident by the inspection conducted by myself on June 20th, 2009, and the Glendale Police Report number 10-5370, dated on March 27, 2010. On June 4th, 2010, Inspection was conducted by Inspector Renee Sada on or about 8 p.m., at which time the entire serving area was being used for a banquet hall and/or private party. The business was not open to the public. The complete report, I have it here for your review. And on June 5th and June 6th, 2010, Inspector Renee Sada also conducted an inspection on or about 10 p.m., at which time there was no activity and the parking lot was empty. Our code-compliant case still remains open with the City Attorney's Office and is currently assigned to myself. And in summary, this business constitutes a nuisance in the neighborhood as related to and/or evident by the following. The addition to the rear of the property without city approval or permits, continuing to conduct live entertainment and dancing without city approval or permits, continuing to receive multiple requests for service from the Glendale Police Departments for noises or disturbances, and continuing to operate as a banquet hall and/or taking reservations for private parties that use more than 30% of the service floor area. Due to the continued disregard by the owner and operator after being notified in writing and in person, the owner continues to operate in violations set forth by CUP 2007-032, and Neighborhood Services staff request that the CUP 2007-032 be revoked and probation or modification of the current conditions not be considered. And furthermore, we are also requesting that the order to include to seize any and all operations until such time that a new CUP can be secured.
Okay, thank you. Is Mr. Sada here today?
I'm sorry, Mr. Sada is also another city attorney inspection.
Okay. Do we have anybody else that has any details on the Friday night, June 4th activity?
I actually have Mr. Sada's complete report here.
Okay. Is that a copy for the
That's a
file?
copy for you. If you like, I could read it in full. I can...
Why don't you just read it and then,
Sure.
then give it to me? Sure.
So
this was Friday, June 4th. This is 2 days after our last, after we were here opening this case.
That's
okay.
correct. This is a report from Mr. Inspector Renee Sada, dated June 4th, 2010. The following is stated. It says, I arrived at 3463 Foothill Boulevard, Urartu Restaurant at 8:16 p.m. and observed an ongoing valet parking service on site with a valet parking sign placed in front of the business on the sidewalk on Foothill Boulevard. The parking lot was full with approximately 40 vehicles parked on the site. I then approached the front entrance of the restaurant and met with a security guard in the lobby area. I identified myself and the purpose of my inspection. I asked if the business or owner manager was present. The security guard stated that they were, but that they were not, but he was the one in charge. The security guard granted me permission to enter the main serving/dining room and kitchen area for the purpose of my inspection. So upon entering the main serving/dining room area, I observed approximately 150 patrons in formal wear, circular tables with matching linen and centerpieces, an area piled with gifts, and a live entertainment area set up in front of the dancing area. No live entertainment was ongoing during the time of my inspection. The full space, 100% of the serving dining area was being utilized for this event. I then entered the kitchen area and observed servers and cooks preparing meals. I then met the security guard in the lobby area and I asked him if this was a private event. He stated it was a christening and that it was a private event. I asked the security guard if they were serving alcohol. He stated the patrons had brought their own alcohol to consume on site. I then left the premises at approximately 8:30 p.m. On June 5th, 2010, I arrived at 3463 Foothill Boulevard Urartu Restaurant at 10:30 p.m. and saw no activity. And on June 6, 2010, he had arrived at 10 p.m. and also saw no activities.
So do you know if it was totally closed or just nobody was there?
By speaking
Nobody
of it,
was in the parking lot?
no, the parking lot was empty and there was nobody there.
Okay. So that's Saturday and Sunday.
Oh, Saturday and Sunday.
Okay. All right. Thank you.
Leave your
Sure.
copy here? Okay.
Sure. Thanks. Thanks, Thomas.
You're welcome, sir.
Okay, I guess now we can hear from a representative of the police department.
Good morning, sir. Lieutenant Bruce Fox, Glendale Police Department, Vice Detail and ABC Compliance. Just a brief outline. I think Thomas did a very good job of outlining on a chronological basis some of the similar concerns that neighborhood services and the police department have encountered with this location. Just going back a little bit further, the police department first became aware of the CUP application in 2008, at which time our department had some concerns about the proximity of this location to neighboring residences. Then in November of 2008, we outlined in a document to the planning department some evidence of already 4 months into the CUP that there was already evidence of violations of the CUP in regard to amplified music permeating the location, not obtaining a valid live entertainment permit, and their inability to keep customers from disturbing the neighbors. In addition, the front and back doors had been left open. Then in the fall of 2008, our department recommended that their live entertainment permit be denied on the basis that in their application to the city clerk's office, they requested the ability to have a DJ and a live band. In researching that, we found out that ABC actually had put conditions on their original ABC license that they be restricted to a 3-piece non-amplified trio. Our department recommended denial of the live entertainment permit based on the fact that there seemed to be a conflict there.
And to your knowledge, the city clerk never issued a live entertainment permit at any time?
That's correct, sir.
Okay.
They did, however, obtain a business dance permit, and our department actually recommended approval of that at that time, based on the fact that it was our position that if they did have a non-amplified trio, they could still have business dance.
Okay.
However, unaware of the fact that there was a section in the code that did allow for other types of entertainment to be provided under the business dance permit. So to that end, when their business dance permit expired in the fall of 2009, our department recommended denial of that. The status of that permit through the city clerk is that it was appealed by the business owner, and the city clerk hasn't rendered any decision on a potential appeal pending this hearing.
Okay. So the latest business dance application is on appeal, which means I guess technically they don't have one since they never issued one.
But no, business dance was issued.
Oh, was it?
Yeah, it was on renewal, and they get granted extensions per the renewal.
Okay. So right now they have an active one, but it's on appeal.
Yes, sir.
By them because the city clerk was going to deny it?
That's correct, sir.
Okay. All right, thanks.
Yes, sir. Then in May in 2009, I received a petition that was forwarded to many city officials from 7 neighbors in the neighborhood adjacent to the restaurant. And the complaint outlined that the business was not adhering to the various city permits, including their CUP, and asking us basically to take action on their behalf. Then I was also provided in May of 2010 a refresh letter from the neighbors outlining 71 incidents from June of 2008 to May of 2010, whereas there had been disturbances and or other activity that had been detrimental to their neighborhood over that period of time. Prior to this hearing, I did research on our calls for service to the police department at that location, and we have received in the 3 years of operation, or 2.5 years of operation, we received 36 music complaints, 5 complaints of loud talking or yelling, 3 complaints of operating without permits, 2 assaults or fights, 2 instances of either the owner or manager on site being intoxicated, 1 report of a patron being refused dinner service at the location, 1 smoking violation, and 1 complaint about disruptive valet operations. That's through to May 27th of 2010.
The disruptive valet operations, is there any detail on that?
Yes, sir. It was outlined in a police report, and let me refer to that real quick.
Okay.
That was March 27th, 2010. And to paraphrase the report, it basically said that valet operations were being conducted and that vehicles were being parked in adjacent businesses. At that time, there was no evidence of any agreements between those private businesses, which were closed at the time, and the restaurant in question.
Okay.
And then I also have, as of our last, I'm going to get to the more recent activity that Thomas spoke of.
Okay.
But I also have 6 police reports generated from this location. 2 of the reports were outlining loud music that was observed by police officers at the site, and 2 of them were permit investigations where they did not have live entertainment permits. Then there were 2 more reports of loud music. And then in February of 2010, I was made aware of, as I mentioned at our last hearing, the State Department of Alcohol and Beverage Control went to the location to do an alcohol beverage control check and observed that the location had distilled spirits on hand available for serving. The owner was arrested and cited out on that violation on that date. Then the report I just mentioned, March 27, 2010, outlines loud music, valet violations, and an intoxicated owner interfering with police investigation at that time. Which kind of leads me to the instances that Thomas mentioned of this previous week. We've continued to monitor the location. We have Officer Joe Perez here with us today, who's actually been to the location on several instances. He can provide you firsthand testimony and answer any questions about this last week's activity. But in a nutshell, what we have is on Thursday afternoon, Officer Perez went to the location to do an inspection and found that there were still numerous distilled spirits throughout the location, including an opened 2/3 full or 4/5 full bottle of tequila in violation of state law. On Friday, we returned to the location, and the same observations that Rene outlined in his memo were observed by Officer Perez, that there was a private party going on inside the location, and message boards that related that it was a christening party for a young person, which seems to be in a different than we were told last week when we were told that there was going to be a private graduation party for the owner's son. There was vodka bottles on each table and people in formal wear. At that time, Officer Perez contacted the State Department of ABC. They advised him it doesn't matter. I'm sorry, let me go back. The proprietor surrendered his ABC license with an effective date of Friday, June 4th. The alcohol was still inside the location on Thursday, June 3rd. That's a violation of state law, because he still had a valid ABC license. And then also on Friday, June 4th, when the distilled spirits were inside the location, just because he surrendered his ABC license, that doesn't grant him the ability to serve distilled spirits. And as you're well aware, it doesn't, and the CUP doesn't grant authority to close down for private parties. So all those things were outlined by Officer Perez in police report, and he's here available to testify as well to those instances of a Thursday and Friday.
So the ABC license was surrendered just Friday?
Yes, sir. It was surrendered Thursday with a effective date of Friday.
Oh, effective. Okay.
Also, for the record, talking to the Department of Alcohol and Beverage Control, the proprietor indicated that the reason he was surrendering his ABC license was because he was going to have a medical procedure done and he didn't want to deal with this restaurant for a month or so, which again is a different story than was provided to us.
Well, why would you surrender it for a month? What advantages under normal circumstances would an operator have? So they're going to, I mean, even if I wanted to close down an establishment, why would I want to surrender my license?
I can't think of it, sir.
There's no
advantage.
Why would I? Yeah. Do you pay less to the ABC? Do you?
I'd have to check on that if there's a suspension of fees, but I do know that the owner purported to me that his inclination to surrender the license was so that private citizens could bring alcohol into his establishment, and he wouldn't have to deal with the restrictions of beer and wine only.
Well, yeah, as we know, that's not really true. I mean,
Right.
you just don't have to deal with.
One other comment of
Some
note
things.
by the owner that was made to Officer Perez, and you can get this from directly, but I found it kind of interesting, was that the proprietor indicated to Officer Perez that he surrendered his license and was renting out his location for a private party, but he was now the customer of for his own private party to throw us on a party. So that's kind of a unique legal question that I don't understand how that quite works.
Yeah, well, in terms of zoning code, it doesn't matter who the proprietor is, who the customer is, or who brings in the alcohol, who pays for it. It's all irrelevant. If it's being consumed or sold, our rules apply. You need a conditional use permit. So whatever conditions we have on the CUP still apply. Okay, I don't know how that relates to the ABC, but
And ABC
our rules still apply.
And the police reports provided by Officer Perez of last weekend have all been forwarded to the Department of ABC, and they are opening an investigation on those instances as well.
Okay. All right, now I guess we could get Officer Perez
Yes,
then
sir.
to just
Thank you.
fill us in a little bit. Thank you, Lieutenant Fox.
Hi, good morning, sir.
Good morning.
My name is Officer Perez. I'm a Glendale police officer. I work Patrol Area District 5, which is the up north in Montrose and La Crescenta area. I've been up there predominantly for about 4 years now and have seen the activities of UR2 since its opening. And it's a building from the Shakey's restaurant it used to be. My first visit at the UR2 was on January 24th, 2010, 23:43 hours. We received 2 noise complaints at the location and contacted the owner, Sir Rob Sorobian, inside. We asked to see his business permits, including his ABC license, and we did not find them conspicuously placed, nor did he have them available for inspection for us. At that
Okay, so the ABC license was not available to
was
you?
not available. The only documents he did have were, I believe, 1 or 2 documents stating application for a license with the City of Glendale.
Was the zoning use certificate prominently displayed?
There was no
Nothing.
no documents were displayed.
Okay.
He had to dig up what the applications he did have.
Okay.
We had warned him on that night that he needed to have those documents available immediately for inspection and conspicuously
Okay.
displayed. Outside of that, the lobby, we did find a lot of people loitering and smoking, but they were all guests of the restaurant. Smoke was entering the entranceway to the dining hall, which is inside the building there. On that night, I had looked back, and we had and that was January 24th. Our first calls were in November 2008, and between November 2008 to January 24th, I had seen that there was 10 calls of either loud music, talking, or fight disturbances in just those 2 months. The next report incident I'd like to touch on is March 27th, 2010. 22:16 hours. Several of officers were dispatched to the UR2 restaurant regarding a noise complaint. Upon arrival, we made the following observations. We could hear music coming or emitting from the facility, and the music could be heard from approximately 100 yards away.
100 yards?
Yes.
Wow.
There were approximately 20 to 30 persons smoking outside near the entrance of the business in a non-smoking area. While we were inside, we witnessed and had to actually step in between a verbal argument that was escalating to physical pushing between 2 females and 1 male. And at that time, we had approximately 4. We requested 4 additional officers and 2 sergeants arrive to assist, and that was on top of 4 officers that were already there. Inside the location, we observed about 250 persons inside and inside the hall, and with DJ equipment set up and running. There was valet staff on scene, and we made observation that the valet staff had occupied the full parking lot across the street, which entertains a Subway restaurant and a cleaners. The whole parking lot was full with UR2's guest vehicles.
The whole parking
Whole
lot
parking
across the
lot.
street was full?
as well as the Everest restaurant, which is about a block and a half away.
Right.
That parking lot was also being used by the valet service. We made contact with the owner, Sarab Sorobian, and we saw symptomologies or evidence that he was under the influence of alcohol, including bloodshot eyes, watery eyes, slurred speech, whatnot. We asked to see his permit for live entertainment or live music. He showed us an application. During that time of our contact with Sarab Sorobian, he became belligerent with us, and after the DJ finally complied of turning off the music, Mr. Sorobian followed us into the parking lot and challenged us to arrest him. And he said if we didn't, he would kick someone's car or steal one of our patrol vehicles. Several of Sarab Sorobian's security guards had to restrain him for a second time that night. And as we started to drive away, Mr. Sorobian ran after our patrol vehicles in the street before he was again restrained by his own security guards. On June 3rd, 2010, I conducted an ABC inspection of a UR2 restaurant at about 1400 hours. I saw the doors were unlocked. I contacted one female inside. She called Mr. Sorobian. I asked him if he was open for business. He said yes, and that he would be on his way. He came about 15 minutes later, went into the dining hall. There were no guests. All the lights were off, but the kitchen staff was there, and the cook told me they were preparing food for weekend parties that were coming. In the east wall of the dining area, there are two fire exits, one on the north side and one on the south side. Both the fire exits were covered from floor-to-ceiling drapes, which you could not see the exit signs or actually detailed that they were emergency exits. One of the doors on the north end actually had a 1.5-inch thick foam board completely covering the door and casement, so as if there were a true emergency and it was dark inside the facility, no one could access the push bar. A second covering for the door and casement on the south door was found laying nearby that door. Fire Department Engine 28 Company, Captain Vasquez, came out and gave notice to UR2 Restaurant to correct those violations. While I was doing my inspection, I saw in the bar area a 4/5 consumed, open and uncapped bottle of tequila. And I went, accompanied Mr. Sorobian after that into his office, where I did an inspection of his office, and I located one bottle of Johnny Walker Black Label, 2 bottles of Johnny Walker Red Label, and 2 bottles of Grey Goose vodka, all stored within a cabinet inside his office. He also had displayed above that cabinet in a type of glass or displayware some Armenian-branded liquors. There's 3 of those. I checked his reservations books. He showed me upcoming reservations, one on June 7th for 55 people, June 12th for 25 persons. And inside the office, we also saw some unopened boxes of tequila and vodka. And we left so I could go check his permits and verify with ABC if he should have this stored on scene. And when I came back to the location about an hour later, the tequila at the bar had been removed, and the cook had stated he uses it for special order Mexican hot sauces, and he had left it there earlier in the day. But when I questioned the cook earlier as to what type of liquors he does use for cooking, he made no mention of tequila, and all the liquors or distilled spirits I found inside Mr. Sorobian's office, the cook indicated he did not indicate to me he had used those. Mr. Sorobian said he keeps the liquors inside his cabinet in case the cook runs out or needs them, and he's not there to go buy them for him. Mr. Sorobian told me that day that he was hosting a graduation party for his son on Friday, June 4th. His son was graduating from Woodbridge Academy, and that he would be having guests, including 39 guests from out of the country. Mr. Sorobian showed me a surrender of license form with the Department of Alcohol and Beverage Control stating on June 3rd, which he went to the Van Nuys office, that he would be surrendering his license for the June 4th event. Mr. Sorobian explained to me that his thinking behind this, or rationale, was if he surrenders his ABC license, he can then close his business to a private event excluding the general public and have his customers bring in their own distilled spirits for consumption and service. At that day, I arrested or gave misdemeanor citation notice to Mr. Sorobian for the violation of the ABC law for having distilled spirits upon the premise. On Friday, June 4th, approximately 21:46 hours, 5 officers, including myself, went to Urartu to do inspection for the private party. That on our way up the driveway, we saw that the parking lot was completely full, including vehicles parked outside of the spaces and encroaching into the driveway itself. Upon entering the Urartu, we saw messages and notices and a LCD monitor displaying that the event was actually for a christening for a 1-year-old gal. We went inside the dining area and we made the following observations. The floor space had round banquet tables with chairs placed around. It appeared each table sat 12 persons. There was not one table in there that was not being used. Each table was numbered, and the number table closest to the doors where we were was number 18. Each table had a centerpiece consisting of approximately 3-foot tall, clear tall cylinder topped with a Minnie Mouse or Disney princess character arrangement. Each table appeared to have the same platters of food. Each table appeared to have a bottle of Grey Goose vodka, and all the bottles appeared to be open. We did not see any beer or wine bottles on the tables, and everything consisted of being a christening or some type of event for a little girl and not a graduation party. As far as entertainment, we saw one male on the stage, appeared to be operating sound controls. Light music was playing in the background, but the music lowered considerably once we entered. We did not see anyone utilizing the dance floor for dancing purposes. And and then there was just children running around the dance floor with balloons or whatnot. We saw uniformed staff tending the tables inside the dining area. We saw the kitchen staff. The bar was not being used or tendered. The guests inside, my rough estimation was approximately 200. Mr. Sorobian later indicated there was 180 guests inside. All the persons inside the dining area were dressed in formal evening attire, suits, ties, cocktail dresses, evening gowns, including the children. It appeared to me that all the persons within the dining area were engaged in a banquet setting for the purpose of celebrating a singular event that all the attendees had a common interest in. We spoke to Mr. Sorobian outside the facility, and I questioned him as to regards to the christening, and he told me that he did have a graduation party inside as well as his nephew's daughter's christening and first birthday. I asked him if more than 30% of his floor space was being used, and he said no, and I asked him if that was a violation of his conditional use permit, being that he can't use more than 30 for any given party, and that it's mathematically impossible for him to have the business closed to the general public and have 2 parties inside and not one or both use more than 30% of the floor space for the parties. Mr. Sorobian indicated that all persons inside were his relatives and that he said anytime anybody wants to close my restaurant, they pay my bills, they can use it. I advised Mr. Sorobian that he was in violation of the ABC law for having distilled spirits upon the premise, as well as now ABC law for entertaining or exercising a privilege of a license holder, since he was not one. Officer Schoonmaker advised me while he was in the parking lot, he was approached by a male that claimed to be Mr. Sorobian's son, and the son gave the following statements to Officer Schoonmaker. This is a business. It's a banquet hall. Obviously, there's going to be parties. There's going to be music. Officer Schoonmaker was approached by a female claiming to be Mr. Sorobian's wife, and she made this statement, "Let me ask you a question. Do you hit every Armenian banquet hall in Glendale like this?" And she was referring to the smoking because she thought we were there to give smoking citations to the person smoking in the parking lot. Officer Schoonmaker talked to another person and asked him if he knew about a graduation party, and that person, who was a guest of the party, said he only knew of a christening party and a birthday party for the 1-year-old. Based on my observations that night from within the location, it appeared to me that the UR2 restaurant was operating or enjoying the facility as described, or as a banquet hall, as described in 30.70.020, the Glendale Municipal Code. Business maintained in whole or in part for public rental for the purpose of private party events, whether family, group, corporate in nature, where access by the general public is restricted, and with or without sale, service, or consumption of alcohol beverages. Later that night, after we left,
Okay.
I didn't issue any citation. We came back because we got 2 noise complaints, and this was close to midnight now. It was about 23, 30 hours.
So, yeah, this is just a couple hours later after you
Couple
left. So
hours later.
how long were the officers there the first time?
First time we were there, I believe it was about 15 minutes or so.
About 15 minutes,
Yes.
okay. Okay.
And the call stated that at first, when we first got there for our first inspection, the music had lowered, but now it had raised again. Once I arrived on scene, I turned northbound on Frederick, which is a street adjacently east of the location, and I parked my vehicles and tried to estimate or distance myself to see how far I could hear the amplification coming from the business. I was about approximately 150 feet away from the location, north of it, from the north property line wall, and I could hear an amplified speaker or someone speaking inside on an amplified device. I made my way to the south side of 4515 Frederick, where it's one of our complainants' house.
Okay.
That's just north of the location. And in that area, along the south side of their house, they have windows. And one of the complaints was that smoke from the smokers at the parking, or in the UR2 parking lot, was entering into that home. At that location, I could smell the strong cigarette smoke. It appeared that the smokers were about 50 feet away from the property line, and those windows are 50 feet south of the north property line of UR2, and the complainant's windows are 14.5 to 15 feet north of that property line. So the smoke was traveling at least 65 feet to make it to the windows. While we were walking back to the Frederick Street to our vehicles, we were approached by a security guard from the UR2 restaurant. We asked his purpose. He said he wanted to see what was going on because he saw some kids in the area earlier. We asked him, isn't your post at the UR2 restaurant and not on Frederick? He said, well, to be honest, I just want to tell you guys they're going to sing Happy Birthday right now at 23:30 hours. And we told him, anything else? And he said, you know what, I was going to tell you guys something, but forget it, and he walked off. This same guard always, upon our arrival, always intercepts the police and always interjects himself into our investigations. This is the same guard that was the one that restrained Mr. Sorobian on the March incident when he was chasing down the police vehicles in the street. And the measurements I obtained were used by a roller tape measuring device, which is what we use for traffic accidents. I visited the complainant the next day, 4515 Frederick, and asked him about the windows, the open windows. It goes into the smoke is entering into the living room. There's vaulted ceilings. The second story of the house is open to those vaulted ceilings, so the smoke comes in essentially and affects the whole house, including their bedrooms. And I had written a police report on that to document the smoking violations, as well as the fact that the amplification from the location is traveling or being emitted from the location and going past the 20 feet limit stated in their conditional use permit. That's all I have.
Do they actually have a designated smoking area on the site?
Mr. Sorobian has made a designated smoking area, which is just to the right of the correction. If you're facing the front door, entering the location, it's to the left along the west fence line. He put 2 benches along the fence line as well as an ashtray container. And his statement to me in regards to that smoking area is he's responsible for the smoking inside. What happens outside in regards to smoking, it's not his problem.
Okay.
He told me, in regards to the valet service, he told me he hires out for valet. It's not his own people, and the security guards he hires out from a separate company. In regards to the illegal addition in the back end of the kitchen, he told me that he did not obtain permits from the city of Glendale because it's impossible to work with the city.
Okay, that's quite a bit. Anything else?
No,
Okay.
that's all I have.
All right, thank you.
Thank you, sir.
Anyone else from police and/or neighborhood services? Lieutenant Fox.
Yes, sir. I just did think of one potential advantage to the ABC surrendering.
Okay.
I believe that one thought process might be that if you don't have an ABC license, you're not subject to the law that states that a member of the ABC or any peace officer can enter your premises and inspect it at any time. That might be one advantage, not being aware that the CUP states that any city staffer can do inspection.
Right. Okay.
And also I want to clarify two things from our meeting last Wednesday that came up in some preliminary testimony. Number one, there was an allegation that the police department had not provided a report of the calls for service to the business owner. I checked with city attorney's office that afternoon and received permission to go ahead and release all calls for service reports. I communicated that to RMIC. And he assured me that on Thursday morning at 9 a.m. somebody would be to my office to collect that report.
Thursday, last Thursday?
Last Thursday, yes,
Okay.
sir. That never happened. I still have the report in my possession. Nobody ever came to claim it. Also, in speaking with the owner, Mr. Sorobian, he claimed that he had a letter from ABC that advised him that he could surrender his license and serve distilled spirits. I asked for a copy of that letter, and I was never provided one either.
Okay.
That's
All
all,
right.
sir. Thank you.
Thanks. I only have one card here, so are there any other members of the public that wanted to speak on this? So we do have Mr. Masihi representing the, well, I don't know, he says other, so last week you were representing the operator, so come on up and tell me what your situation is today. And
Hello, my name is Haber Minas Masihi,
okay.
and I'm sort of representing Mr. Seraf Sorobian. And,
Sort of representing. What? Could you be a little more specific on that?
Yes, I'm not here to represent the case because that would be the attorney's job, and I want to turn in 2 letters I have from the
Sure.
attorneys.
Sure. Now you're a planning consultant, basically, or in what capacity are you sort of representing the operator? Whatever that means.
Speak on his behalf, but I won't speak on the case because that's the attorney's job.
Okay.
I just want to say that Urartu Restaurant has the right to be represented by an attorney, and the reason that the attorney has requested for another extension of time is because of the lack of extension of time. When we requested for a continuance, we were assuming the hearing officer would give us 2 to 3 weeks, but since it was only for 1 week, it was a significant amount of time to review all the legal documents, which were just the police reports were available on Thursday, but there are more than that.
Okay. Well, apparently nobody picked up the police reports on Thursday. Do you know
Yes,
why
but
that
there are
was?
more. There's more than just the police reports, and we are also in the process of hiring a land use attorney, Mr. Ben Resnick, the law firm of Jeffrey Mangitz, Butler, Morrow.
Okay. That's what this letter.
That's what
That
that
right?
letter from Urartu Restaurant states.
Okay. Last week, when I asked you who the attorney was, you said you were working with 2 attorneys, but you didn't have their names. So we got the letter from Mr. Baker late yesterday saying he was hired on Monday afternoon. So he wasn't one of the two attorneys you were referring to, and this letter says you're in the process of hiring the firm of Jeffer, Mangitz, Butler, and Marmaro, represented by Mr. Resnick. And then this letter from Odala Suarez says, I've been contacted by Urartu Restaurant and will be retained. So who's actually on board? Who have you actually hired? Or not you personally, but who is the owner actually hired? Just Mr. Baker?
He'll be hiring Sheldon Baker, and Ben Resnick, I'm assuming, will be on the case as well, or the law firm of Mr. Ben Resnick and Odala Suarez. So
Okay,
as
well,
of
again,
Monday, that would be 3 attorneys, I believe.
Okay. Yeah, one of the reasons I'm not continuing this is these issues, all of these things, including but not limited to the illegal addition, are issues that are over 1 year old. So why is the owner waiting till after the initial, essentially after the initial public hearing to consider revocation, still working on hiring representation at this late date? Why didn't they hire somebody earlier if they thought they needed help with this?
It's from...
Why now?
Well, the CUP revocation was submitted this year. I don't think that's been an issue for over a year, right?
No, this has been an issue for over a year.
Not the revocation of the CUP.
It was these issues, the issues that caused
The
this
addition,
hearing
yes.
to be scheduled in the first place, are over a year old. The addition, the banquet hall activity, the noise, all of those are over a year old. Why wait till now?
Because now is when the hearing was scheduled.
The hearing was scheduled, about 6 weeks ago, something like that, Ms. Toledo, I believe?
Approximately.
And as you mentioned last time, the operator had no particular issue with last week's date, and even as late as a week before
No, like I stated last week, I contacted Mr. Sorobian prior to scheduling the hearing, and I mentioned to him that it would be scheduled for June 2nd if he had a conflict, and he said no, that he would be available and that date was fine.
Okay. All right, so then I take it you're not going to comment on any of the issues? Noise, smoking?
No, I won't be commenting on
addition.
that. But the reason for a request last week when we were here is because of the police reports that weren't available to the public.
Well, as Lieutenant Fox said at the end of the last meeting, you didn't somebody didn't ask until the Friday before a 3-day weekend.
Yes, if it's available to the public.
Why wait that long?
The hearing was for Wednesday.
Yeah, well, they waited until the Friday before a 3-day weekend to ask the police department.
I believe it was a Thursday when we asked the police department.
It just seems like they have knowledge of all these issues and they're not dealing with them. The addition's been around for well over a year. To your knowledge, what have they done to deal with just the addition? Clearly, they have to do something about that.
I won't be speaking on that.
Okay.
But they are acting because, as you can see, they're hiring or in the process of hiring 3 attorneys.
Yeah, well, it's in the process of that is a little
Odala
confusing
Suarez
why they
is
would
on
wait
the
this
case,
long.
as the letter states.
Again, I'm not. It is what it is, and I've given you my reasons for not continuing this case because it's essentially been going on the issues have been going on for over a year. They've had plenty of opportunity. So, anything else you want to add?
No, just that they have the right to be represented by an attorney, and
Okay.
that's the reason why we would ask for an extension of time.
Okay. Thank you.
Thank you.
All right, with that, I'm going to close this hearing. I'm going to take the all the evidence that's in the record from last week and this week and all the written correspondence into consideration, and I'm going to be making a written decision as to whether or not to not revoke, suspend, modify conditions, all the options that are available in terms of the ongoing jurisdiction of conditional use permits. So we should have a letter coming out fairly soon. And as I said earlier, just like any other hearing officer decision, it can be appealed within 15 days of the date of the decision, which again will be the date that's on the letter itself. So that case is closed. Going to turn the hearing over to Mr. Hamilton for consideration of the other cases. And hopefully Mr. Hamilton will be here in just a minute.
얘기를 많이 했는데 그쪽에서 얘기 하나도 안 했어요.
This is all this one.
Okay. For everything so far? No, I got Honolulu next.
Good morning. My name is Jeff Hamilton. I'll be the hearing officer for this case. The case is PVAR 2010-011 and conditional use permit case number PCUP 2010-021, located at 2448 Honolulu Avenue. The applicant is Kip Clayton Architects, Incorporated, representing the business Trader Joe's. And the project description is the development of a Trader Joe's market on the site that is about 1.1 acres. The proposed 14,670 square foot single-story building will be located on the western portion of the site. Adjacent will be a 60-space parking lot. The project is located in the C2-1 zone, Community Commercial Zone, Height District 1. And it is described as portions of lots numbers 311, 312, and 313 in tract 1701. The City of Glendale actually owns the site on which the market is proposed, and Trader Joe's will lease the land from the city. The application for the variance is to allow the installation of a new projecting sign which exceeds the maximum size and thickness requirements for a projecting sign and is indirectly lit, and that is to be located on the building. The application for the conditional use permit is to allow the off-site sales of alcoholic beverages. I'm going to open the hearing now and ask for any comments from staff on this case.
I can do a quick presentation and also clarification. When the public notice was announced and published, at the time we thought that the sign would be
indirectly illuminated, which required a variance application. It is not, so that is actually not part of their request at this point.
So the sign will not be indirectly illuminated?
It will be illuminated from not from inside the sign, but from outside, which is allowed.
Okay.
Yeah.
Yeah.
Okay. All right, good morning. The applicant is requesting approval of a conditional use permit to allow the off-site sales of alcoholic beverages at a proposed Trader Joe's market, and approval of a variance to allow the installation of a new projecting sign which exceeds maximum size and thickness requirements to be located on the building at 2448 Honolulu Avenue. As you mentioned, the city owns the site, and it is currently developed as a surface parking lot. It's located on the south side of Honolulu Avenue between Sunset and Orangedale Avenues. Staff believes that the findings can be made to support the approval of both the conditional use permit and the variance. Regarding the variance, the proposed projecting sign is located at the entry element of the building and faces both directions of Honolulu Avenue. As proposed, the sign will be 24 square feet in size and 12 inches in thickness. The city sign regulations require that projecting signs not exceed 6 square feet in area and 6 inches in thickness. Strictly applying the sign regulations will result in unnecessary hardship, inconsistent with the intent of the ordinance. One intent of the sign regulations is to prevent businesses from installing excess signage, which creates clutter and detracts from the appearance of the buildings and the commercial areas in which they're located. To reinforce this intent, only one projecting sign is allowed per ground floor occupancy, and the size is restricted to a very limited 6 square feet. Sign thickness is restricted to a maximum of 6 inches to maintain appropriate scale with a maximum size. The proposed Trader Joe's projecting sign will be 24 square feet in area. However, there are no wall signs proposed on the building. Under the code, Trader Joe's would be allowed to have 2 wall signs, a 124 square foot sign facing Honolulu Avenue and a 136 square foot sign facing the parking lot located east of the proposed building. While the proposed direct projecting sign is 18 square feet larger than what would otherwise be permitted, it's significantly less than the maximum 260 square feet of wall sign area that could have been installed on that building. Additionally, since the proposed building will contain only one occupant, no other projecting signs will be allowed on the building, even though the building frontage on Honolulu Avenue is much wider than a standard commercial frontage. And standard commercial frontages in the area are generally 50 square feet, or 40 or 50 feet, I'm sorry. Given the size of the projecting sign, the proposed 12-inch thickness is appropriate to maintain sign proportions. Staff does recommend prohibiting the installation of wall signs on the building to ensure oversigning on the building does not occur. Staff also recommends requiring removal of the projecting sign should Trader Joe's vacate the site. The design of the building on the property is driving the need for the projecting sign variance and is the exceptional circumstance which warrants granting the variance. The style of the building was an important component in developing the project site, since the site is located west of the Montrose Shopping Park. The city, which owns both the land and will own the building, Trader Joe's and the surrounding community have had significant input on the building design and believe it is very important to develop the site that would integrate and complement the Montrose Shopping Park. The style of the proposed building harkens back to commercial buildings constructed in the early 20th century. The importance of the architectural style of the building and the locations of the proposed elements that carry out the design in effect limit the placement and the placement and type of signs used on the building. Large wall signs, which are commonly installed in commercial developments, would clutter the proposed building. The proposed projecting sign, while larger and thicker, will be located in the upper portion of the entrance tower and will become another architectural element of the building and reinforces the proposed style of the building. The granting of the variance to allow installation of the projecting sign will not be detrimental to the public welfare or injurious to the property or improvements in the neighborhood. Installation of the proposed sign will require issuance of a sign permit. Obtaining a sign permit and subsequent inspections will ensure the proper installation of the sign. Projecting signs are required to have a minimum clearance of 8 feet above, between the bottom of the sign and ground surface, and the proposed sign has a clearance of approximately 14 feet, so well above 8 feet. As previously mentioned, the proposed building is designed in a style reminiscent of early 20th century commercial architecture found in the Montrose Shopping Park. The proposed projecting sign is also reminiscent of early 20th century commercial signs and is complementary to the style of the building. Therefore, granting the variance for the proposed sign will be complementary to the property and on-site improvements and will build upon the uniqueness of the nearby shopping area. And finally, the granting of the variance to allow the installation of the new projecting sign will not be contrary to the objectives of the ordinance. The intent of the sign regulations, among other things, is to create a more attractive business climate, enhance and protect the physical appearance of the community, reduce advertising obstructions, and curb deterioration of the community environment. One of the means to enhance the business climate is by providing flexibility in standards. While the proposed projecting sign exceeds maximum size permitted for projecting signs by 18 square feet, and this increase may be significant, the 24 square foot sign is much smaller than wall signs which could have been proposed. Staff, as previously mentioned, suggests adding condition to the project that wall signs will be prohibited on the proposed building. Regarding the conditional use permit, the off-site sales of alcoholic beverages will be consistent with the elements and objectives of the general plan. The land use designation of this site is community/services. One of the purposes of this designation is to serve community shopping functions. The proposed Trader Joe's is a market selling a full range of grocery items, including produce, dairy, meat, frozen foods, and dry goods, similar to a larger chain supermarkets in the area. Supermarkets also commonly sell alcoholic beverages in conjunction with the other grocery items, and the sale of alcoholic beverages is a reasonable extension of the other items that these types of businesses offer. The off-site sales of alcoholic beverages at proposed Trader Joe's market will not be detrimental to the safety or public welfare of the neighborhood in general. Trader Joe's sells alcoholic beverages at all its locations, including the 2 that currently exist in Glendale. And the alcoholic sales at those 2 locations haven't posed any problems in the past. In addition, those the locations of those Trader Joe's don't have any open code violations, which suggests that the new Trader Joe's will operate responsibly. While there are more off-site establishments in this area than otherwise would be allowed, this census tract includes the Montrose Shopping Park, which is a large neighborhood commercial retail center. The project site is located in a neighborhood commercial area where a concentration of retail uses is encouraged. Additionally, while the area has more crime than other areas of the city, it also has a high concentration of retail uses, which may partially explain the higher crime rate. Neither the police department nor the neighborhood services division cited concerns related to this conditional use permit, and particularly the number of establishments selling alcohol or the crime rate. The off-site sales of alcoholic beverages at the proposed Trader Joe's will not adversely affect or conflict with adjacent uses or impede the normal development of the neighborhood. Immediately east of the project site is the Montrose Shopping Park. and that area contains a significant number of restaurants and retail uses. The sale of alcoholic beverages for off-site consumption does not conflict with these land uses, and the project will not impede normal development along this street as it is already fully developed, and it shouldn't impede any redevelopment of the street given the proposed conditional use permit only requests the sale of alcoholic beverages. The applicant's request does not result in inadequate public or private facilities, in that the project site is proposed for development of a 14,000 square foot market building. Neither the Public Works Department nor Glendale Water and Power cited any concerns related to the adequacy of the public facilities or the existing public facilities. And the conditional use permit is required only to allow the off-site sale of alcoholic beverages. The sales of alcohol will not in and of itself create an additional need for facilities above that of the building. So again, staff recommends approval of the CEP and the variance with the draft conditions contained in the staff report.
Thank you. Related to the projecting sign request, is staff aware, are you aware if projecting signs are a common feature in the Montrose Business Park area?
They're fairly common in early 20th century commercial buildings. We've got, actually, I think on the other side. It's an early streetscape, and then these are pictures of buildings in the area that the proposed sign was modeled after.
Yeah, there do appear to be, from these old photographs, it does appear that projecting signs were pretty common historically in the area. And at least by my eye, the proposed sign is quite similar in style to these. I noticed too that the buildings were mostly, or many of the buildings were brick architecture, so obviously the new building has quite a lot of brick, at least in the facade. Is staff aware of any other markets in the area that are sort of reasonably nearby? I'm thinking of like the Vons on Verdugo or the Ranch Market to the west. And do they have alcohol sales?
I don't. I suspect the Ranch Market to the west does have alcohol sales, but I'm not certain. But the Vons and the Ralphs and the pharmacies sort of in the area and the surrounding area do have alcohol sales.
Okay. Okay, I don't have any other questions of staff at this time. I'm going to open up the hearing now to the applicant. The applicant has 15 minutes time to speak on either of the two matters.
Good morning. My name is Kip Craig from Kip Clayton Architects. My address is 814 West Chapman in Orange. We're the applicant and the architect for the project. Speaking for the signage and the architecture, we spent considerable time with city staff developing the architecture design, and the sign was a pretty important process in developing the architecture, trying to stay in suit with the architecture of the time, the early century architecture, and as you could tell in the pictures, we tried to formulate the signage process pretty close to what those parameters were back in the early century architecture.
Yes.
As far as a conditional use permit, we were the applicant for Trader Joe's in that regard as well. As far as how Trader Joe's services and provides alcohol in their stores. I'll let Doug Yokomizo respond to that. But if you have any questions about signage, I'd be more than happy to answer those. And I wanted to thank Roger from staff for his support of what we're trying to accomplish with the property that's owned by the city.
Are you satisfied that the one projecting sign is going to be adequate to your needs, and are you in agreement with the proposed conditions about no wall signs and removal of the projecting sign if the site is vacated?
Well, again, I'll let Doug from Trader Joe's address that issue. It has been my experience in the past that with Trader Joe's as being their architect that limited signage is a tough play, but I'll let him address that issue for us.
Okay.
Morning, Mr. Hamilton. Doug Yokomizo. I'm Vice President of Real Estate for Trader Joe's Company. Yes, under the current plan, building plan, we intended to rely upon the one projecting sign plus the monument sign, and that's, we're planning to go in with no exterior building wall signage. But, this lease that's proposed calls for a 10-year term with options to extend it for another 30 years. And I'm a little uncomfortable going in with a condition prohibiting us in the future from having the flexibility to add building wall signage, especially as landscaping matures, times change. I'm just very uncomfortable committing that will be the only signage we have. On this projecting sign, you're talking about 12-inch letters. A typical retail establishment, including Trader Joe's, our signs are 36 inches to 48 inches. That's pretty standard. So going in with 12-inch letters on a building of this magnitude, I have some reservations about it, but we're happy with the design that's been developed. We understand it's very important to staff, but we want to keep some flexibility. So what I was requesting is, there are, under code, if we weren't doing this projecting sign, we'd be allowed 260 square feet of building signage, which would allow us to do, I believe, two 48-inch letter signs. We don't think that's appropriate for the building. We don't think that's appropriate for the neighborhood. We would never propose something of that nature. But I would like to keep the flexibility in the future to have, 24-inch letter signs if we determine that that's necessary or advisable. We would agree to additional conditions that they not be internally lit, so they would be halo lit or externally lit only. And that would be my only comment on the sign conditions.
We have a process that if we adopted the conditions as proposed, you could always come back and ask for a modification to the conditions. So the condition states that you can't have signs, and that's in effect unless the city granted a modification to the condition. Is the fact that process exists sufficient, or is that not sufficient and you would rather have the flexibility up front?
I would rather have the flexibility up front. I mean, this is a ground lease. We're contemplating spending several $1 million on this property. It's not something I would be comfortable with committing that down the road that people will say, oh, yes, go ahead, you could now change your signs. We know it's important to this community. And if you're coming in just on that issue, it's going to be more difficult for us to get that flexibility. I mean, as I was sitting here listening to the last matter, I was listening to the CUP, person who holds that CUP apparently has a condition that they could only have a 3-piece non-amplified band. Well, I'm sure at the time they entered into that CUP, that was all they contemplated. They didn't realize down the road as their business developed, they would want to have a DJ and live bands and some of these other things. This operator, I don't want to take sides in it, but they didn't realize that they needed flexibility as their business evolved to do something other than a 3-piece non-amplified band. And I don't want to be in that situation 15 years down the road where we think we need a sign on this building because our one projecting sign is now covered up by one of the trees we planted, and you can't tell that this is a Trader Joe's, and to find that we don't have that flexibility.
I respect your position. The difficulty I have is simply that staff report does not anticipate the wall signs. In fact, they make the argument, part of their argument for why it would be reasonable to approve the projecting sign is that there won't be any wall signs and that it avoids cluttering the building. So I'm not comfortable right now with your request because we have no evidence in support of what you're asking, and I would be directly contradicting staff if I were to just simply grant it in the absence of any facts or evidence.
Well, I would agree. 260 square feet of signage on this building would clutter that neighborhood. It would be inappropriate for the neighborhood. But if we were to simply withdraw the request for a variance, we would be allowed that by code. We could do that by right. I don't think that's where we want to go, but I do believe we can submit, additional photographic evidence of, other similar type projects with projecting signs that also have building signage. I don't think it'll be difficult to find other examples.
Okay. That may give us a way to proceed.
Okay. Then if you have any other questions about the alcohol or any of the other issues?
Does Trader Joe's typically sell a full range of alcohol?
Yes.
Hard liquor included?
In California, that's correct.
Okay. We've heard we've heard some evidence that there have been no problems with the Trader Joe's in Glendale. Is it your impression as a Trader Joe's representative that generally your clientele is reasonable and responsible, at least while they're on the site?
That's my impression of them. Anybody who's willing to spend with them, I think, spend with us is reasonable. But we are a grocery store. We don't refrigerate our alcoholic beverages, other than things that are intended to be sold in single units. We don't sell single units of beer. We don't make it easy for people to abuse alcohol. It's intended for use at the home.
Coming back to the sign briefly, is it your impression that many or some Trader Joe's customers drive around and stop off on a whim, or do they typically know where they are going and go there with the intent of going to Trader Joe's?
I would say there's a certain percentage that are going to be those convenience whim people who are just driving by, but most people, I think, go to a store as a destination.
Okay, I don't have any other questions, I don't think, at this time. You still had a few minutes, I think, available to you, but do you have anything else to add?
No, I don't.
Good.
Okay, thank you very much.
Thank you.
Thank you, Mr. Hamilton.
I have 2 speaker cards for this application. First is, I think it's Kip Crane, or... Oh, that's Kip Craig. I see, okay. And Dennis Yokomizu. Does anybody else in the audience wish to speak to this item? Okay, there's no speakers. Typically, we would offer rebuttal time to the applicant, but in the absence of any speakers to the contrary. But I do notice Lieutenant Fox being in the in the room, and I would like to ask him a couple of questions from the police department.
Yes, sir. Lieutenant Bruce Fox, Glendale Police Department.
We have statements in the staff report that there is, in fact, an overconcentration of alcohol sales in the area, and that there is evidence that the crime rate is perhaps above the average for the, I forget if it was for the city or for the census tract?
For the city, yes, sir.
Okay.
That census tract.
The census tract has an above average crime rate for the city.
The census tract has an above average. Okay. Is it police's opinion that it makes it more or less difficult to sort of manage crime up there because there's a concentration? Does the fact that they're close together make it a little bit easier rather than being dispersed, or can you shed some light?
Yes, sir. I believe that the overconcentration law, as it's been established, was to prevent the, if you will, the example we have maybe in our neighbors to the south in Los Angeles, where you have blighted neighborhoods that have been plagued with liquor stores, especially when you speak to off-sale, liquor store on every corner and subsequent loitering and other problems related to that. As far as policing the Montrose shopping park in and of itself, overconcentration as it already exists is not a problem, and is actually, as you mentioned, somewhat beneficial to have all of the off-sale locations in a similar area is not a problem for us, and does make policing a little bit easier, actually.
Do you notice, would you describe the Montrose area as blighted?
No, sir. I bring that example up of why the law was even enacted to begin with of overconcentration.
Yes. Would you say that there's a significant problem with people loitering or drinking in public?
No, sir.
That's all my questions. Thanks very much.
Thank you.
Since I see no other speakers, I'm going to close the public hearing at this time. I am going to take the request for alcohol sales under submission, and I'll be issuing a decision letter on that probably within the next couple of days. On the item of the projecting sign, I don't feel comfortable taking that under submission and closing the hearing on that yet, because I just do not have enough facts and evidence to support the request. What I would like to do is ask the applicant to provide evidence that would allow staff to analyze the potential effects of the wall signs that they have in mind. The kinds of evidence that I have in mind that should be provided to staff would be drawings of what these wall signs might look like and where they might be located. And it doesn't have to, I'm not saying that would commit you to that particular style, but I'd like something that staff can use to evaluate the issue of whether or not the building would look cluttered, and whether the sign would be the signs that you have in mind would be compatible with the building and its style. We need something in the evidence that would assist staff to come to a different conclusion than what they've currently written. In addition to the drawings of the signs, I'd like to see photographs of the Montrose Shopping Park area, in particular any buildings that have a combination of projecting and wall signs. So again, staff can evaluate whether those buildings with that combination look cluttered, or whether they look reasonable and aesthetically pleasing. Finally, I'd like to have photographs of any Trader Joe's that have a combination of projecting and wall signs. Again, to evaluate whether this has been done elsewhere, and whether those buildings look cluttered or whether they look aesthetically pleasing. Those should all be provided to staff well in advance of the next hearing, so that staff can make an evaluation and produce a revised staff report and reevaluate whether the existing findings and the arguments in support of those findings need to be changed. We need to continue this item, that particular item then, the variance for the projecting sign, until some future date. Does staff have a proposed date in mind, or have you been able to, or does the applicant?
Sorry, we can, in 3 weeks is June 30th. We can do that as long as it's okay with you and the applicant.
June 30th works for me. Will June 30th, to have this go on June 30th would mean that you would have to provide this material probably no later than June 22nd, maybe 21st, so that staff has enough time to review it and produce a revised staff report. Does that give you, that's, just about 2 weeks from now, does that give you enough time to prepare the materials that you would need? To respond, please, one of the applicant's representatives, please come to the dais.
Yeah, that would be sufficient time for us to respond.
Okay, excellent. Then we'll continue this item to a date certain of June 30th, 2010, with the applicant to provide materials to staff no later than roughly June 21st.
Well, we can work with them on
the date?
On the dates, yeah.
Okay.
Yeah.
Very good.
Thank you very much.
Okay. The hearing on this item is closed. The next item on the agenda is PVAR 2009-039, located at 2700 Piedmont Avenue. The applicant is Shoag Yepremian of Yepremian Consulting. The owner is Havset Karamichian. I think that's what it is. The project description is an application for a setback variance to allow for the construction of a 4-unit multi-residential development project, condominium townhouses, with reduced front setbacks along Piedmont Avenue. There's an existing single-family house on the site addressed as 2690 Piedmont, and that will be retained. This property is located in the R1650 medium high-density zone, described as portions of lots 181 and 182 of tract 2535. At this time, does staff have a presentation?
Yeah.
Good morning. Just as briefly described, this is a standards variance for a setback for the property located at 2700 Piedmont Avenue. The application is to allow the construction of a 4-unit residential development. It's a condominium townhouse style project on a 10,390 square foot lot zoned R1650. And as I show you, this would be the existing site plan survey, and these plans would be the proposed project. The applicant is proposing a setback variance of, now again, based on zoning code for multifamily residential developments, there would be a minimum 20-foot setback, 23-foot average for the garage in the first story, and a 23-foot minimum, 26-foot average for the second and third stories. Because there is a jog at Piedmont Avenue, essentially the project has 2 street front setbacks. This would be along the northerly 82 linear feet of frontage on Piedmont, at which point the street jogs south. There's approximately 122 linear feet, again along the westerly property line, which would also still be considered the street front setback.
So why would this not be considered any other corner lot that just has a street side setback?
Because it is the same street that jogs around it. So as opposed to an intersection of 2 streets such as Piedmont Avenue and Honolulu, that would have a street front and a street front and a side street setback. In this case, because it is the same street, Piedmont Avenue, which essentially just jogs around, and it is a corner lot, because it's the same street, it essentially would have to, it requires the project to meet street front setbacks on both sides,
okay,
both elevations. Brief project description: there's an existing duplex at the front of the property. There is a single-family detached unit to the rear. This particular project was reviewed by the Historic Preservation Officer. The existing duplex was found not to have any historical significance. It's not on any register. However, the rear detached unit is of the storybook style architecture, and it was found to be one of the last remaining examples of this type of storybook architecture. And as such,
very distinctive.
It is a rather distinctive building. The applicant property owner has decided to maintain, based on recommendations by staff, to maintain the existing structure and actually to build around it. There are also a number of protected oak trees on the site. You'll notice that 2 of the protected oak trees are being maintained and preserved as part of this project as well. In order to allow for, in order to grant a standards variance, there have to be 4 findings made, and all 4 findings in this particular instance can be made for this project. First finding would be that the lot is unique in comparison with the surrounding lots in this neighborhood. Again, this is because it has 82 feet frontage along Piedmont, at which point it jogs and has 122 linear feet of frontage along Piedmont as well. This would essentially require that the project have a minimum of 20-foot setback on both sides. This particular intersection, by having a jog, is the only type of intersection within 500 feet of the project. All the other corner lots essentially have a side street and a front street setback. The side street setback would essentially be 5 foot minimum, 8 foot average on the first and second, or on the first floor and garage level, 8 foot minimum, 11 foot average on the second and third floors. So other properties in the area are granted the side street and front street setbacks, where in this case, this lot, because the street itself is the same one that jogs around it, is rather unique. Second finding required would be that the lot features site constraints that limit multifamily residential development, as would other be associated with other RT 1650 lots. Given the Piedmont jog and having two frontages, two front street setbacks, again, this property also deals with requiring to have the rear detached unit be maintained, the storybook style home, and also to address the protected oak trees. So there are several site constraints that would limit otherwise typical R1650 development on the project site. Third item would be that strict application of the setbacks would institute a particular practical difficulty or unnecessary hardship inconsistent with the general purposes and intent of the ordinance. Again, for the same reason stated, you have a lot, it's a corner lot. Typically, you would have a front street and a side street setback. In this case, you have two of the elevations that would require to be 20 feet minimum, 23 foot average, 20, and the typical front street setbacks. Not only that, but you have a lot that is essentially 66 feet in width, that's perpendicular to the side and interior elevations. In this case, if you were to require a 20 foot or a 23 foot setback along the front in addition to the interior setbacks, you'd really be limiting the development just within this narrow portion of the lot. Last would be that granting of the setback variance would not be detrimental to the public welfare or injurious to the property or surrounding neighborhoods. You'll notice from the aerial that is on the screen right here, you'll notice that there is multifamily residential high-density developments all around on Piedmont Avenue, both to the north and to the what essentially would be the west and to the south. Once you get past to the west, you'll notice that you'll have R3050. So you'll still have multifamily residential development, but the majority of it would be a medium high density residential development to the north, south, and to the west on Piedmont. All these other properties have the ability to go ahead and construct to the R1650 standards in this particular case because of the various site constraints and because of the unique situation regarding Piedmont. This particular property would not be able to be built according to the typical multifamily residential standards as would other R1650 lots in the area. As such, staff recommends approval of this particular setback variance request based on the findings that can be made. I'm available to answer any questions you may have. Also, this project is scheduled to go before the design review board following the discretionary approval, if it is in the best interest.
Thank you. I have a question about the existing house. Is the existing house currently occupied?
No, it is not. Oh, you mean the duplex is vacant?
No, the storybook home that's being preserved.
The storybook home is, I'm looking at the property owner. The last, when I was there in the last site inspection, it was occupied. I'm not sure as to its status right now. It appears that, based on the nodding heads in the audience, that it is still occupied.
Okay, I have a couple of questions, or one or two more questions about that situation. I'll ask the applicant when they come forward. Let's see. When I visited the site, I noticed that there were some lovely old stone walls along the sidewalk. Are those stone walls going to be kept as part of the development of the site?
The current proposal does not indicate that those stone walls are being kept. So
Does not indicate, or
No.
do you know if they're going to be removed, or just not sure?
it appears from the proposed plans that those walls will be removed.
And to staff's knowledge, are those walls, have they received any sort of permit from the city, or are they essentially grandfathered?
Those walls were built at a time when the particular property was not in the jurisdiction of the city, so those would be legal nonconforming. According to today's code, anything greater than 18 inches would not be permitted in the front or side street setback. So these walls are grandfathered in, and they are not legal conforming to today's code.
Okay.
Before I forget, we received one email from Mr. Grant Michaels. He is with the Homeowners Association of the property at 2710 Piedmont Avenue. You'll notice on the aerial photograph that is the larger multifamily residential condominium townhouse project that surrounds the property, both to the west and to the south. There was some concern regarding the fact that this is a 3-story complex adjacent, what is currently a 1-story project that's going to be developed into a 3-story. So there was a little bit of concern regarding the massing and privacy issues. But again, I mentioned that he would be able to go ahead and have comment and say during the design review board process if it deals with the massing issues. Because again, the setback variance for this particular project only deals with the side setback along Piedmont Avenue.
How tall, does staff know how tall the existing units are there to the west of this proposed site?
In terms of height, I would guess
Are they 2 stories or 3 stories? Or?
it's an existing 3-story structure.
It is an existing 3-story
Correct.
structure. Does staff know, do you know if the terrain is any higher on that property than on this property? Or is it essentially level across the 2 sites?
Well, Piedmont, this particular project site, and I'm assuming that the same one adjacent to it, has a slope from the north to the south of approximately 8 feet, and so there is a slight change in grade from Piedmont south.
I mean, in this direction, across this way, is this site higher than this site?
I believe
I understand that Piedmont, there's a falling in the
Correct.
topography in this direction, but
If there's a very gradual slope change from going from west to east.
Okay.
So the project site, the neighbors would be slightly higher, but again, I would have to confirm that with a survey or with our engineering department.
So you say that it's a 3-story next door?
Correct.
And roughly the same topography in terms of elevation as the project site? Okay.
I would have to confirm that. And I would like to note that the project, as proposed, appears to comply with the minimum standards if the project was being built for a side street setback. So again, although the code is requiring that the project have the street front setbacks along both the north and the easterly property lines, in this case, the applicant has submitted a project that complies with the front street setbacks for the northerly section. Again, this would be the 82 linear feet along Piedmont, along the north property line. So that complies with the required front streets, or the street front setback. Along the lengthier portion of 122 linear feet along the
easterly
top,
property line.
The easterly property line, that would comply with the code's required side street setback. So it is in compliance with the intent of the code by having a front and a side street setback. But in this case, because of the actual definition of a street front versus side street setback,
Yes.
They're required to have 2 front street setbacks.
Very good. Okay, I'm going to review some of the comments that have been submitted by other departments for the case. We've got comments here related to the oak trees from Anne Marie Sheets. And I noticed in reading the staff report that there is a condition of approval that the applicant pay if I recall right, pay a fee essentially for the value of the oak tree that will be lost. Am I correct?
That is, yes. The project proposal has been reviewed by our urban forester. There is one mature oak tree that is being removed, and there will be a mitigation fee paid for the removal of that oak tree. The other trees are being preserved.
So I thought I had seen it as a condition, but I don't see the condition saying that the fee shall be paid. Was it a condition of the project, or was it a mitigation measure?
It was not a mitigation measure. In this case, there was not an environmental information form or initial study done because of the number of units on the property. The project would have to comply with the protected oak tree mitigation measures established by our urban forester. The project would also have to comply with the historic preservation for the storybook home. Those can be either included as conditions of approval for the setback variance, and they will definitely be included as requirements for the design review board approval.
Okay. I see a variety of comments, conditions from the city engineer's office. In my experience, these look fairly common, fairly standard, involving replacement of sidewalk, curb, and gutter, and providing a drainage plan, and things such as this. It does appear that the project will require a sump pump to deal with water that gets into the subterranean parking area, and that'll be a condition or requirement when it goes through plan check. There's a comment from Tom Mitchell from traffic that the access looks like it might be inadequate, but I've understood in talking with Mr. Mitchell that he's now satisfied with the revised. These comments were for an earlier plan, and now with the revised plan, he's satisfied with the. Is that correct, Mrs. Zimatitis? Have you
Yes.
received similar had a similar conversation?
Yes, Mr. Mitchell had a comment regarding the width of the garage door opening, and the plans have been revised to address that comment. The garage doors have been widened to approximately 19 feet.
Got comments from fire that they need ladder access. This will be coming through as part of plan check. It's not a condition per se. And similar comments from engineering in regards to fees and other items that will have to be dealt with during the plan check process. And that looks like the last of the comments from staff. City staff. Okay, I'm going to open the comment and public hearing comment portion of this hearing. And first, I'd like to invite the representative of the applicant to come up. They have 15 minutes to present.
Good morning, Mr. Hamilton. Shobak Yepremian Consulting in. I apologize for my voice. You have my address on file. I'm representing the property owner of the subject site 2700 Piedmont, and he is here present with his son as well as a project designer if you have any specific questions about the design of the project. We have been working with staff, particularly Vilya and your historic planner, for the last 2-3 years. Initial application was submitted in 2007 for design review board meeting. However, since then, issues came up, such as the historic or potentially historic nature of the back unit, as well as oak trees. So 2 consultants were hired to analyze the historic structure in the back. Both of those consultants did not really indicate that the project was historic. Staff had some concerns about their conclusions. So the options were either to go through the environmental impact report or to do a citywide study to come up with the conclusion that staff would be satisfied, which would have been impossible for my client to do. So therefore, he agreed that he will maintain the back unit. All these things took time. An arborist report was prepared in 2007, then an amendment a few months ago to address the 4-unit project versus 5 units. So the process took 3 years. So I'm glad we're here today, thanks to Vilja, again, to expedite this project. Again, what you see is a project to demolish the front units and to construct a 4-unit development while maintaining the rear unit in the back that's potentially historic. 3 main issues, again, that's unique for this property. One is the historic structure in the back and working around preserving this structure. The second issue is, again, the uniqueness of the property is the fact that there are 4 oak trees on the property. One is at the northeast corner at the intersection of Piedmont. One is near where the new driveway will be located, and 2 oak trees that are behind the potentially historic structure.
So staff, excuse me for interrupting, but staff is showing 1 oak tree behind there or your plans show 1. There's actually 2 back
The
there.
arborist report showed 2. If you read the arborist report and their site plan, it showed 4 total. Based on the new version that you have now, the oak trees in the back will be preserved. The oak tree at the front will be preserved as well. So the only oak tree that will be removed is near the driveway. And the only reason that will be removed because the new driveway will be at that location.
Okay.
So this is a better version than the 5-unit development. So therefore, more oak trees will be preserved. The architectural style that you see in front of you will be reviewed by the Design Review Board at future time for compatibility purposes, and we do believe that the project is compatible given the number of units and the neighborhood that it's located. The project itself, again, is a 4-unit development. The unit sizes that we propose range from 1,495 square feet to 2,105 square feet, townhouse-style units. The middle 2 units are the only units that have 3 levels. So you can see from setback perspective, they're further in compared to the first floor and second floor. Again, as Vilja mentioned, the third item that's unique about this property is the way Piedmont jogs. Initially, staff determined that it's a corner lot, typical corner lot. Later on, they determined that because it jogs, entire frontage of Piedmont will be considered frontage. Therefore, front setback requirements apply, 20 feet, 23 feet. So that made this project more difficult to comply with the code requirements. So therefore, a setback variance is necessary to at least develop this site with 4 units while preserving the back unit. Again, just like Vilja mentioned, the side portion of the property, which is the east side, complies with the street side setback requirements, which is 5. I do have the dimensions again for those, which is minimum 5 feet for the garage, first floor 5 feet, second floor 5 feet, and third floor is 17 feet. So especially with the third floor, it's quite a distance. So we do believe that the project meets all the findings. As I prepared the application, I submitted all the 4 findings as required by this office. Vilja also supported my findings. We submitted all the relevant applications, and hopefully we can get an approval for this project since it's been 3 years. So we do appreciate a quick decision on this case. If there are any questions of me or the project designer or the property owner, I can take those now.
Ms. Yepremian, can you clarify whether or not the stone walls that are on the edge of the property, are they going to be kept or not?
They are not indicated on the plans. I can check with the project designer. That may be discussed during the design review process, but he can address if those can be maintained.
Hi, my name is Gary Akopian, and I'm designing this project. And we had like 3 years of a time to fall in love with that storybook house, and now we're ready to adopt that perimeter wall too, since it's basically the riprap and texture of that stone that we have on that perimeter complements to the first floor stone veneer that we have in a proposed plans. So it's possible, yes.
Okay, excellent. Now, you will, if I read the plans correctly, if you keep it, you will have to punch some hole openings through
some
it?
entrance to some access to the side.
Do you foresee that as being, would that compromise the structural integrity of the rest of the wall? Is it all going to fall down if you do that, or are you going to be able to?
From a structural point of view, I'm not confident now, but I believe it's only perimeter wall interfere with the new structure at all. No, we could do that.
Okay. The back unit, it's currently occupied.
Yes.
What provisions are going to be made for the occupant during construction?
We were actually discussing that earlier with the property owner. There are tenants right now in that unit, perhaps either to have a shield. I'm not sure what, he needs to discuss that with the residents to see if they can stay there during construction, and dust and noise would be, of course, a concern. But if they can put some kind of a shield to protect that, I'm not sure if it's doable. He just needs to discuss that with the tenants, possibly move them out for a few months during the critical construction time. He just needs to discuss that with the tenants to see how much they can bear.
Yes. Okay. I don't think I have any more questions for you, Ms. Yepremian.
Thank you very much, Mr. Hamilton. I would like to say we have reviewed the staff report and the conditions proposed by staff, and we do agree with the conditions that's in the staff report.
Oh, I did have one other, related to the conditions. So it sounds like you wouldn't be opposed to a condition to maintain the perimeter stone walls?
According to the project designer, it may be possible to maintain.
To the extent feasible that's compatible with the
Correct.
walkways and whatnot?
Correct.
And would you be amenable to a condition to pay the fee for the loss of the oak tree?
Yes, that was discussed. The arborist report that was prepared second time as an amendment, I believe he discussed that with the city's arborist as well as the property owner, and they agreed with that amount.
Okay.
So
There is agreement on the amount now.
He's aware of that amount.
Excellent.
Yeah.
Okay. That's all I have for you.
Thank you.
I have 2 speaker cards for this. Hovannes Karamachian. Are you speaking on his?
Here being present and hearing the case, but I don't believe they need to add anything. They're not comfortable in speaking today.
Okay.
So.
Very good. Are there any other speakers in the audience that would like to speak to this item? Please come forward with your speaker cards. And just provide them directly to me. Well, let's go ahead and put that into the record when you speak at the dais, at the lectern. So, could you please state your name and address for the record?
My name is Doug Ward.
Okay.
I live at 2710 Piedmont Avenue, Unit 16. And this complex will be pretty much, I don't know, 15 or 20 feet in my front, right in front of me. So I sit to the rear, or my unit would be to the west of the
proposed?
the southern, yeah, probably to the west of the southernmost part of the complex.
So you're in one of the units
Yeah, yeah.
on this side?
Yes, yes.
So you'd be directly adjacent?
Yeah. Right now, I look on a concrete backyard of the currently existing structure that's there.
Okay.
And so should I read these letters first, or how are we doing this?
You have 5 minutes total.
Okay.
What I would recommend is that you provide me with the letters, and then maybe you could summarize some of the thoughts from the letters.
Yeah,
But you should give me the letters now if you want to
sure.
put them into the record.
I think probably building a new structure on this site would be a good thing, because the current condition of the building that's in front of us is, it's old, it's kind of falling apart. My only concern is, I've lived in 2710 for 10 years, and I don't know if this building that's going to be going in, one of my concerns, having had incidents in our building where we had to have emergency vehicles come and deal with a person in our complex, the corner where Piedmont jogs and turns is very, very congested, and a lot of times when fire trucks try to get in there, they end up blocking the street. They don't have any choice because it's hard to get access to our building because we're sort of an L shape where that pool is. There's no good way to get to our unit. So one thing we would suggest is to, on the curb in front of 2700, would be to make that a red curb so people can no longer park there. Because I think it seems that this new building has adequate parking underground, so that's not that much of a concern. But I've just seen too many times where fire trucks have had a real hard time in our area. The other thing I'm also a bit concerned about is just the height of the building. We already don't have much of a view, and I think with the new building coming in, I don't know that we'll have any view anymore. I am concerned, and I think those letters are concerned just about the privacy issue, and because there's been a number of tenants in that complex over the years. One of the previous tenants were some guys that built a skateboard ramp, and we could see guys shooting up in the air in front of our window. So we haven't been happy with all the people that have been living there. So that brings me to the point that I am not sure if these are going to be condominiums that people are going to buy, or if this is just going to become another rental property with people coming in and out. So there's some other issues that Grant is going to bring up just about the whole height of this building and the underground parking. So I'm not saying I'm opposed to the project, but I do have some concerns. And I know there's going to be another design review coming up later, which I think I and maybe some other people would like to be present for.
Yeah, typically the zoning hearing officer is not responsible for the aesthetics of the building. I would be more focused on the site planning, the arrangement of the buildings on the property.
Yeah, aesthetically it looks great.
But I understand your concerns. I hear your concerns. Okay. Thank you very much.
Okay, thank you.
I have a card here for Grant Michaels.
Hi, I'm Grant Michaels. My address is 2710 Piedmont Avenue, number 12. To clarify one issue, The complex that we are in, which essentially surrounds this entire property, the pool at the south end of the property belongs to ours. Yes, they are 3-story townhomes, but from street level, there's only 2 stories. The driveway that we have slopes down significantly, and all of the garages are true subterranean garages. From the picture of the different
Can I just clarify that for my purposes? Are you saying then that from the driveway side, they are essentially 3 stories tall, but from the exterior portion, they appear as 2 stories tall?
Unit number 12, that is my unit. The front door...
Oh, I'm sorry, sir, you're going to have to...
Yeah, we can't pick you up over there.
You can come up to the micro... forgive me,
You can come up
Mr.
here
Hamilton.
if you want to point at something, but we need you at a mic.
Unit number 12 is my unit here at the front. Unit number 1 is here. The driveway slopes down significantly to the back of the complex.
Yes.
From the street, the driveway slopes down, and my front door is actually entering into the second level. There is a garage, there is a second level, and there are bedrooms on the third level. From the sidewalk, you walk down approximately 2 feet to my front door.
Okay.
So the front door at the second level is below street level.
Okay.
From street level up, it is 2 stories.
Flipped it around.
So it's 2 stories above street level
Correct.
if you're out here, but the driveway must then drop fairly sharply over
As
here
right. You
to be
can
3
see-
stories?
Coming down this way, you can see part of the slope of the driveway. And looking at the pictures from the storybook house that overlook the pool, you can see the storybook house being 2 stories at the level of the pool.
Yes.
From here, you can see the pool, and then you see 2 living stories. This view might be a little bit better on the monitor. For
Vilya, is there a way that you can rotate it to provide on the monitor to provide this view? This view here?
Sure.
Oh, no, well, never mind. This photograph at the top pretty clearly demonstrates that from the street,
there is a
the driveway
significant
drops
slope.
quickly
Yes.
down.
So,
Okay.
yes, they are 3 stories, but from the front street level, it is only 2. The concern I have is with the 3rd story setback. Looking at the designs here, the construction of this building is essentially level with the front of the street. So there is, while our building in back slopes down, each of the units step down. This building will essentially be level across the top. There will be the 3rd story, I believe the 2 bedrooms and the balconies that will look out and be a full story to a story and a half above the roof line of our building.
I would agree with your analysis.
So we are concerned about the 3rd story with essentially bedrooms and a balcony overlooking master bedroom windows in our complex. And we also are curious to find out, as Doug mentioned, whether these will be rental units, whether these will be for sale, how the storybook house will be integrated into the plan.
So it appears to me that at the 2nd story level, there are bedroom windows towards your property.
Correct.
Neighboring property to the west.
And
Now on the 3rd story, there are no bedroom windows in that direction. There are 2 bathroom windows and there are 2 balconies, but the bedroom windows actually orient to the east. On this
correct.
This level. These windows are bathroom windows facing your side.
all this space is your side. So these are bedroom windows, and I think these are bedroom windows down here. No, it's this.
It's far away.
It's the kind of balcony and bedrooms and master bath that's pushed back a little bit further.
Given this configuration, and there are no bedroom windows at the third story, are you still have some concerns?
The concern is for the third story in general and the open-air balconies that would essentially be at a full story above the roofline of our complex.
Okay.
Additionally, as this structure doesn't appear to slope with the south-facing slope of Piedmont Avenue, towards the back of the complex, those windows may be significantly higher than the adjacent windows from our property. The other townhomes that are built along Piedmont all follow the same slope of Piedmont Avenue to the south. So we do have the central driveway belongs to Piedmont Oaks, which is at 2710 Piedmont. The adjacent building with a different roof line is another condominium complex. That also follows the slope down Piedmont. So essentially, all of the townhomes on Piedmont are 2 stories and they follow the same terrain. The concern with this is simply there is a third story and it doesn't follow the terrain from the frontage at Piedmont.
Okay. That level of detail is...
I understand that may be more for the design.
I think that's a little more for the design review, but I'm going to thank you very much for your... Do you have any further comments?
No.
I
do want to go ahead and see if you can ask those questions of whether the units will be for rental, for sale, how the Storybook House will integrate into the design.
Right. Thank you very much. I had a question for staff. Does the building conform to the height limits of the zone?
Yes, it does. It conforms to not only the height limits, but also to the interior setback. I believe there's actually a 10, if I'm not mistaken. The living spaces from the interior setback have a 13-foot 8-inch clearance from the interior setback. And the third floor, I don't have a scale drawing in front of me, but it looks to be about 15 feet from the interior setback. They have a 15-foot interior setback.
Whereas they're required to have?
Whereas they're required to have, I believe it's an 8-foot minimum, 11-foot average.
For the third floor?
Correct.
The neighbors have also raised some concerns about the parking along Piedmont. Do you know if there are any red curbs in front of the property right now?
No. This project was reviewed by Tom Mitchell, the Traffic and Transportation Assistant Administrator, as well as the Fire Department. No concerns were raised at that point in time, but I'd be more than happy to discuss that issue with them again.
If I could ask a representative for the applicant to come forward. Are you familiar, do you know if there are any red curbs directly in front of on your side of Piedmont or across the street?
I don't remember. Is there one?
Yeah, there's one right on Piedmont.
Okay.
Which side?
Well, just...
Oh, actually, you can...
Where it turns into the corner.
Forgive me, Mr. Hamilton. You can see where, from the photographs.
Right there by the side.
Okay, yeah. Then
So this portion, it'd be this,
But I don't
that's
think it goes
facing
to the
north.
thing.
and then it goes for some
See?
distance down this
So it goes
direction.
here.
Turns about a car length on the,
So maybe a car length.
right there, yeah.
There, because you can see right
Right.
here to here, and then it goes clear.
Well, oh, I see. It doesn't go the whole length. It's maybe a car length there and maybe a car length here.
Correct.
the corner.
Basically just near the hydrant.
Correct. And then when it turns the corner here, you can see
No road, no red curb.
there's a little red curb right
Yeah.
here on the corner, but then it's
Right.
it's open.
Would the applicant object if we added a condition that said there should be red curbs on the your side of Piedmont for your frontage?
If the city's fire department or traffic department requires it, then we have to comply. So I would have to refer to those departments if they would justify the reasons why there should be a red curb. So far, they have not required it, so staff perhaps needs to check with them and see if they will.
Velia, do you recall ever having a conversation about red curbs with either fire or Tom Mitchell in traffic?
Again, based on our previous conversations and circulation of the plans, there was no concern mentioned at that point in time. I'd be more than happy to discuss it again.
But did you have any specific discussion with them about that issue?
No.
I know they didn't express any special concerns in general, but
No. It appears, again, from the photographs and from the project site, the immediate area to the corner is red curbed.
yes.
There appears to be like one car length in front on the northerly side, where from the photographs you can see that there's a mail truck and a little minivan that's parked there. I'm not sure if that's completely the way. And then you have the driveway to the two-car garage off of Piedmont Avenue. So that garage and driveway will be removed. I'd be more than happy to discuss this matter with the Traffic and Transportation Administration and Fire to see.
The site plan shows that the right-of-way width or the easterly property line is as narrow as 50 feet, and then the right-of-way is wider on the northerly property line or at 60 feet. Do you have any idea what the improved width of the streets are?
I do not have that plan in front of me. I know that Piedmont is wider along the northerly property line simply because, and that's also the particular street which serves the R1650 zoning. So you have higher density residential along that Piedmont. Then once Piedmont jogs to the south and then continues to the east, you're looking at a zone that's R3050, which is smaller scale residential, so you're going to have a narrower roadway width when you have, single family and based on, the previous subdivision of the area. And again, this predates the city of Glendale. This was previously in the county of LA.
Okay.
I'm being handed, looks like from the county tax assessor records, it appears that there's a 60-foot roadway width along Piedmont. This would be in the R1250 zoning. So
Typically, the assessor's office shows right-of-way.
this is only the right-of-way. So a 60-foot right-of-way and then a 50-foot right-of-way once it jogs and continues in the lower density residential neighborhood. But again, unfortunately, this is only right-of-way. I don't know what the public right-of-way, what the improved roadway width.
Well, just looking at the aerial photograph, it looks like the improvement is two traffic lanes in each direction, one traffic lane in each direction, and it looks like there's parking, probably room for parking on both sides of the street. So if we assume the traffic lanes are 12 feet, that'd be 24, and then a parking lane of 9 feet on each side, 18 and 24 be 42. So probably roughly 40 feet of, it looks like there's roughly 40 feet of improved width in the 50-foot right-of-way, which would give basically 5-foot parkway and sidewalk on each side.
I would have to confirm that with Public Works Engineering because I know that they actually have a small landscaping strip along both public right-of-way, the sidewalks within the public right-of-way.
It might be a little bit narrower, but it looks like there's room for 2 travel lanes and 2 parking lanes right now. I mean, just looking at the aerial photograph.
Mm-hmm.
It might be narrow if there were 2 cars on each side plus cars trying to travel at the same time. But okay, thank you very much.
Okay, thank you.
I'm going to review these letters that were handed to me now. First letter is from Ronnie Garcia, Unit 14. They're writing to oppose the project. Don't need another project like this. It's too big. Parking they're concerned about. And I think it will take away from the beauty of the area. The Jong family, who live next door also at 2700 Piedmont, are concerned about privacy and pollution. Concerned about noise and air pollution. Okay. Is there anybody else in the audience that wishes to speak to this matter? Seeing none, I'm going to close the public hearing. I'm going to take this matter under submission, and I'll be issuing a written decision letter in the near future. I think I have enough information to proceed and take action on this. Oh, I'm sorry. I need to reopen the hearing. I forgot. The applicant has a chance for rebuttal argument. You have 5 minutes for rebuttal in response to any comments from the neighbors.
Thank you, Mr. Hamilton. I heard the neighbors' concerns about the red curb, the height of the building. Again, we do believe that this is a reasonable development for this property. It's only 4-unit compared to other multiple developments in this area. Almost every single project on Piedmont received height variance, setback variances, as my experience indicates. The red curb, I do recommend that staff checks with fire department as well as traffic department to see if they recommend it or require it. Again, if we look at the setbacks for the third level, there's ample setback for the third level. I believe some 30-foot average from the front, north side of Piedmont. Again, from the side, it's beyond the minimum and the average as required by code. The third level is, again, allowed by code. The remaining issues that they raised is up to the design review board in terms of compatibility, in terms of design compatibility with the neighborhood. And again, mass and scale will be all under design review board jurisdiction. Again, we're here today just to address the setback issue from the Piedmont east side, so I hope your decision is a favorable one. Again, we have worked with staff for over 33 years, and this is the best solution we can come up with on this project, preserving the oak trees as well as the historic structure in the back. Again, the setback is the only item for your decision today, and we do hope you have a favorable decision. Thank you very much.
Thank you much. I have no questions. Now I will close the public hearing again, properly. Pardon me? I know. Thank you. Okay, so I'm going to continue this item. I'm going to take this item under consideration, and I will be rendering a decision shortly. Thank you very much. Okay, I have a third item on the agenda. PCUP case 2010-003, located at 831 East Colorado Street. Applicant is Williams Land Use Services, representing the Hookah Lounge, and the owner is Afik Hunanian. The request is to obtain a conditional use permit to permit the upgrade from on-site sale, service, and consumption of beer and wine to full liquor sales at an existing restaurant located on the site, which is located in the C31 Commercial Service Zone, Height District 1. The applicant has contacted staff and informed staff that due to a family emergency, they cannot be in attendance today. I do not see them in the audience. And staff has, we do not have a date certain, I don't think, at this point about when this can be continued to. And I don't see Mr. Nazarian here to to be able to respond to that. So we're going to have to continue this to a date uncertain, so which means that any future hearing will have to be renoticed, and notice will be given to all property owners within 500 feet of the project site. I will be the hearing officer on any future hearing at the time whenever it comes back before the city. This closes all the public hearings on the agenda. Are there any reports from staff or on any items?